Mr. Yolt.
I was in the I was in the Court of Appeal decision, and I was just about to turn to paragraph 68 and following, which is under the heading whether to order otherwise on the set-off issue. In paragraph 68, just a small point perhaps, but the Court of Appeal suggested that the reason that we were bound by the decision in the Prudential group was a cause of action estoppel. I think it's more, well, it is in that sense. There was a judgment, and therefore we couldn't raise it, but it was in the same proceedings, so I'm not sure that you would even describe it as a cause of action estoppel. There was simply a judgment in those proceedings from Mr. Justice Henderson, which wasn't appealed. So that's why we were bound by it. But it's paragraph 69 in which they sort of summarise their approach to this issue. In the particular and highly unusual facts of the case, it's appropriate to order otherwise because by analogy with the principles applying to issue estoppel, there are special circumstances which otherwise create injustice. And then they set out their reasons. And there are they set out broadly four reasons. The first one is the point about appealing. And they make the point in paragraph 71 that it would have required a significant degree of prescience to have anticipated in 2014 that there's a realistic chance of the relatively recent decision in Sempra being overruled. And they point to the significant developments in Littlewoods and Investment Trust subsequently. And we would go further that even if you had that prescience, it's very unlikely that the courts would have had the similar prescience and granted permission to appeal. The only basis in which you could have applied at that stage was a rather Mr. Micawber type attitude that hoping something will turn up between then and when we get to the Supreme Court. And then they deal with Supreme Court 3. And the cause of action estoppel, issue estoppel arguments in that case, because you'll remember in Supreme Court 3, the taxpayers were saying, well, we can't take this point about Prudential being overruling Sempra because of issue estoppel, etc. And the Supreme Court said, no, you can take the point in relation to those in, well, the test claimants and all the followers following on in the FII GLO. The second point then in paragraph 73 relates to the impact of the decision in Prudential Supreme Court. And they're simply making the point that the result of the litigation in FII is that the only companies in the world who are not bound by Prudential are some of those in the Prudential group litigation, which the Court of Appeal thought was rather ironic. Everyone else, including all the followers, all the claimants in the FII were bound by it. And then paragraph 77, the third point, the stage of the litigation, they're pointing out there that GREA's claims were stayed and have yet to be determined. And they thought it would be wrong for them to be determined at this stage on the basis of an understanding of the law, which is known to be incorrect. And they draw an analogy there with the Arnold case, which they look at. And the fourth point is this. If you recall, in Prudential, the Supreme Court said that it was a logical consequence of Sempra that the claimants were entitled to compound interest for what are called periods B and C.
Categories B and C.
So categories, yes, categories are, well, they are periods, yes, categories B and C, which are the periods following either the payment of unlawfully charged ACT, which wasn't utilised, so remained outstanding, or the period after the set-off up until the time of judgment. And those were treated in the same way because the period of prematurity, the SEMPRA period, was regarded as creating a principal sum for which you could claim immediately after the set-off. You could have made a claim then to recover the time value for that period. And it was said, therefore, by not paying it, you had a cause of action at that point, and therefore interest should run thereafter.
And that interest is really interest, whereas the category A primary amount is not really interest, it's just the compensation is calculated by reference to the amount that you would get by compound interest.
I think that's one way of putting it.
Yes, I mean, it was a device to meet Saint-Georges.
Yes, yeah. It was the obvious way of measuring the restitutionary remedy for that period. But yes, you're right. It produced.
But surely, it's, looking at the third reason, surely it's inherent in the scheme of things that the follower's claims are not yet going to have been determined when you have a test case. But the whole point of the thing is to that they're going to be bound by the result. There can't be much of a reason for not treating them as bound by the result that they haven't yet been determined, the claims.
I think, to be fair, that they are differentiating perhaps a situation where a test claimant or indeed the defendants are saying in the follower claims, we would like to argue for a different position, and a situation where the court, in giving judgment following, if it were to follow the GL determination, it would know it was giving an incorrect judgment. It would know it was applying the law incorrectly. I think that's a difference that they're saying. When you get to deal with someone's claim, it's very odd for a court then to say, well, we know the law is X, but we will apply Y. I agree, there might be situations where they know that the law has been said to be X, and the claimants say, actually, it should be Y.
Yeah. That
would not be a situation where you would necessarily order otherwise, because you wouldn't give them the opportunity to argue why. I think that's the point that the Court of Appeal are making. There they are. Sorry, the fourth point, though, was the illogicality. The reasoning in Prudential was, first of all, if SEMPRA is right, then the B and C periods must be compound interest. That just follows from the reasoning in SEMPRA. So what they said was, well, SEMPRA is not right, it's overruled. As a result, B and C were then not compound interest. They were under Section 35A. And I think what the Court of Appeal is saying is it's odd in a situation where that was the reasoning of the Supreme Court, that you would be awarding someone interest on a SEMPRA basis, but then interest thereafter under Section 35A on the basis that SEMPRA was right. SEMPRA was wrong. So you're applying the law to B and C on the basis SEMPRA is wrong, and applying the law to A on the basis SEMPRA is right. That would be what you would be doing. And that's the point they're making. It produces an illogicality in this particular case.
So do you say that the test then set out in paragraph 69 of special circumstances which otherwise create injustice, are you adopting
yes, I would support
We're saying
that.
There's nothing wrong with that.
Nothing wrong with that, yes, exactly. And it does follow the overriding objective to deal with cases justly, etc. And then in paragraphs 82 to 85, they deal with AXA's arguments, balancing them against the points that they've made. And they're essentially some of the points you've heard. Two bites of the cherry. There's no distinction between the followers and Prudential. But they then say in 83 They don't accept the submission that a decision to order otherwise in this case would adversely affect the conduct of other GLO litigation by incentivising claimants to attempt to make their claims test cases. And they make the obvious point that this could work both ways. You become a test claimant, you might find the law has changed after your claim is finished, which would be in your favour, but you're not able to take advantage of that. The reverse of what happened in this case. So it's difficult to see that anyone would be wanting to become a test claimant just because of this. So they would have it would be equal odds that they would win or lose if they're taking account of this point. Of course, it's much more important that being a test claimant actually involves quite a lot of work for the company. I mean, they have to prepare witness statements. They have to do a lot of work on them in these GLOs, particularly. They have to do a lot of work on finding out what dividends they paid, what tax they paid in the past, etc., in order for the test claims to be determined. So that would be, in my submission, a far more important factor than the vague possibility of exceptionally a case like this that they might end up winning or losing. And we do say generally that this is not undermining the finality and the policies of the GLO procedure. We are talking about, we would say in this case, a very unusual, indeed one might suggest a unique circumstance. Because in most cases, the points would be challengeable at lower levels and appeals would be brought. So you wouldn't get into this situation purely because of the very unusual circumstance of SEMPRA being overruled in this particular litigation even, that's caused this problem to arise. We're certainly not suggesting that there should be open season to order otherwise in GLOs. And nothing that the Court of Appeal have said would give credence to that suggestion. They made it clear that these are exceptional circumstances, special circumstances they talk about. So that was all I was going to say about the set-off point, unless there's any other questions. The second point is different. This is limitation. And the question there, first of all, is was there any determination of a GLO issue? Now,
so could I pick you up just on one point in your written case at page 90 in the key documents bundle?
Yeah.
Where you give a number of reasons, and the fifth one is that your position in advance of the hearing in the inner house, in the Supreme Court, was that the Supreme Court should determine what the law was so that the correct law could be applied to the followers, even if for procedural reasons it may not apply to Prudential. Can you vouch that proposition?
I think, this is on page 90.
90, paragraph 84.
84. I'm not sure what the Supreme Court said in Prudential was one of the factors that led them to overruling SEMPRA was this was a GLO.
Yes, but but it wasn't distinguishing between Prudential and the followers in relation to Category A.
It didn't. Page, I'm told. Sorry, I think there is something on page 995. I'm told of the bundle. think that's a claimant's submissions that this should be determined because of...
Is the appellant's
it's our
response
submission.
to the cross appeal?
It's our submissions, yes.
It's your submission?
Yeah.
In which paragraph?
It's paragraph 4. I think this was a general point we were making, that you should decide it, even if it doesn't matter to Prudential, because this is a GLO and it should be determined for followers. I think that's...
Or was it that point, or was it the point about distinguishing between category A and categories B and C? Because it could have been said, you've conceded category A in Prudential, everyone accepts that it would be illogical for B and C not to follow A, therefore we're not going to decide any of them. But Sempra Metals only strictly decided category A, I think.
I think the point, though, is that what we're saying in paragraph 84 is not just focused solely on the point of that we're dealing with now. It's a more general point. It was just, we were simply saying in advance of the hearing, the Supreme Court should determine what the law was in general, and that's this paragraph. So I'm not suggesting. I don't think this paragraph in our case is not suggesting that we had specifically addressed this point about Sempra and category A in advance. It is just saying that this was our position, that they should determine what the law was so the correct law could be applied to the followers in general. So I think that's what this paragraph is saying.
Yeah, but in any event, it was a response to the issues raised in the taxpayers' cross appeal, which
yes,
were different matters, as I recall.
Yes, that's right. Yes, exactly. Yeah. Because this was an appeal by the issue we've been discussing was an appeal by the revenue. That's right. Absolutely. Yeah.
Thank you.
Yeah. Yes, sorry. So I don't
you're
think...
wanting to move on to limitation.
Yeah, I was going to move on to limitation. Yes. Now, you have heard described what happened in relation to the issue headed limitation before Mr. Justice Henderson. We have set it out in some detail in our case between paragraphs 118 to 156, and it's also set out in the Court of Appeal between paragraphs 94 and 112. But I think I can summarise it as follows for these purposes. The issue which we were been looking at in Prudential in first instance was split into two parts. One was simply a question about the whether Section 320 One was simply whether Section 320 of the Finance Act 2004 was valid, and that was a question that was going to be determined by the European Court of Justice. So Mr. Justice Henderson didn't have anything to do about that. He didn't have to say anything about it. However, the other issue was in a sense, a pleading point. It was a question about relating back claims. And you'll have seen that the way the issue was set out, and perhaps we can just take Mr. Justice Henderson's judgment, and you can see.
So this was whether the 6 years
it's page 2178.
would run from the date of the amendment or the date of the addition of them to the claim, or whether it related back to the earlier date when the proceedings were started.
When the claim was started, yes,
yeah.
Exactly. Yeah.
Sorry, what page did you see?
It's 2178. And so you can see set out at paragraph 249 the procedural history of the Prudential claims. And Mr. Justice Henderson says the questions fall to be answered in the light of the following procedural history. And there's the various amendments, etc. And there were two companies. One had brought their claims originally in 2003, and one, which I think is Prudential Holborn, had brought their claims in 2004. And both of them, as with all the members of this GLO, both of them amended their claims in 2009 to bring in claims for ACT. For some reason, claims for ACT had not been included in the original.
Well, that was before the 12th of December 2006.
Well, it was, but then the claims in FII all made claims for ACT, and they were brought in 2003 as well. So there's no particular, I don't know. There obviously was a reason why this happened, but anyway, this is what happened. So they brought the claims for ACT by amendment of their claim forms in 2009. The other thing to remember is that ACT was abolished in 1999. So therefore, there wouldn't be any claims in respect of ACT essentially from that year, after that year, because no ACT was payable. And the question therefore was, and this was on the assumption, and there's a little bit of confusion here, because I think Mr. Justice Henderson may have got this the wrong way, but the Court of Appeal, I think, got it right in this Prudential case. The question was, on the basis that the Section 320 was valid, and therefore you could only bring claims for 6 years in mistake as well as in Woolwich. In those circumstances, it became important as to whether they could relate back their claims brought in 2009 to the earlier date, either 2003 or 2004. And indeed, there was an even more cheeky claim by Prudential Holborn that they could relate back their claim brought in 2004 to the date when the other company brought their claim in 2003. Now, that was rejected by Mr. Justice Henderson. But the other question was, did these claims in ACT arise out of the same facts, etc., as the claims that had been brought in 2003 and 2004? And if they did, they could relate them back, and therefore they had 6 years back from then, which meant they could make claims in respect of periods when ACT was, in fact, payable. Now, this is all on the basis that Section 320 was valid. If Section 320 was invalid, then we go back to 32(1)(c), and there is no doubt that sub silentio, it was the assumption that everybody made that DMG was a law, and therefore the Prudential claimants would be in time. I say the Prudential claimants advisedly because of the date in which they brought their claim. It wasn't being conceded that any other claimants who brought claims at any other time were in time. In fact, it wasn't expressly conceded at all. This is the odd thing about this. It seems that Mr. Justice Henderson deduced this, possibly, I suspect, from discussions that we might have had in earlier cases, because we were dealing with these cases all the time at that time.
So wait a minute, you said sub silentio, it was the assumption everyone made that DMG was the law, and on that basis, in the absence of Section 320, if it was invalid, then their claims would all be in time.
Then it would be academic, which I think is what I said, as to whether they related back or not.
You said a moment ago that you said advisedly, you applied that only to Prudential, I think. Why just
Well, that was the only claim that we were focusing on at that time.
Oh, okay. Right.
It wasn't. We weren't conceding anything in relation to claimants who,
PHL.
for instance, brought claims later.
PHL. Did it apply to PHL as well?
Yes, both of, sorry, the Prudential group. Yes, those,
Group, right.
yes.
Everybody was going to be bound by the outcome of this determination. And the question comes down to, doesn't it, whether an assumption that underlay the order but isn't expressly set out in it is nevertheless treated as having been established by the order.
I think that's exactly the point, my lord. Can it be, well, it's not, can it be a decision on a GLO issue? And we say, the first point to make is there was no GLO issue on the question of discoverability in section 32(1)(c) at this stage, this hearing.
Is that because of the difference in wording between the wine garden order and the schedule?
Just because there simply wasn't an issue set down to be determined as to how.
It wasn't a specific issue.
It wasn't.
The question is whether it comes under the general issue, whether the claims were brought in time, or I can't remember what the wording was.
Yes.
Well,
The original order did seem to raise this point, I thought.
Which order? Oh, you mean
The third, whatever.
You mean the GLO itself?
Yes, whichever one.
it said, didn't it say what is the date from which?
Limitation is a general issue in that. Yes.
No, but
No.
what is the date from? My lady has it there.
Well,
When one is dealing,
it asked, what is the date?
yes. When one is dealing with a GLO and a hearing,
Yes. If you look at 380,
this is in the actual order originally.
yes.
Yes. But
From what date does the applicable limitation period start to run?
yes. But you can't simply go back to the GLO order and say that everything within the GLO order isn't necessarily a GLO issue in a particular hearing.
Well, is there anything you can point to that says that someone decided that was not something we now need to decide? So there was some specific change in the wording later because that was now rejected.
Yes, the issues, GLO issues that were agreed for the hearing and ordered by Mr. Justice Henderson altered that to the extent that these are the issues that had to be determined.
So,
Can we just look, can you show us what they say? So we've got that in front.
Yeah, those are the ones that my learned friend I think showed you that are appended to the order.
they're in the Court of Appeal judgment.
It's 659
They probably are
and
as well,
660, I think, are the two questions.
Yeah, they're set out.
To see them.
So although these are appended to the 28th of January 2014 order, are they in identical terms to some earlier
These are
pre-trial?
well, these were all agreed pre-trial. As being,
So where is it that they were set out when they were agreed pre-trial?
I'm not sure. I don't know where I'd find that, but there was an order. I think there's an order.
Will have been some
issue.
pre-trial review or case management
Yes.
hearing or something at which they finalised the list of issues.
It's actually very conveniently found in paragraphs 94 and 95 of the Court of Appeal judgment.
Yes. I mean, there is an order. Sorry, I can't find it.
I mean, it quotes the order.
The order,
made
yeah.
by Mr. Justice Henderson at a case management
Yes.
conference on the 20th of December 2012.
Yes, so it's Schedule 1, agreed list of issues.
The original order that is referred to in paragraph 94, that was back in 2003.
Back into the...
The original GLO order, which is quoted in part in paragraph...
That would be in 2003.
So DMG came after that, didn't it?
Yes.
That may be quite significant in the way that the issue was, as it were, narrowed.
If you look at the GLO, as with all the GLOs I've seen, order, that will state issues in very general terms, and so it's necessary to be more specific. If you're having a hearing to decide an issue,
Yes.
to decide issues, you've got to determine what these issues are more precisely than there are in the GLO order.
Well, that
So it's not-
seems to be more precise than the
But it,
ultimate GLO.
but it's not one of the issues that were listed.
Well,
No, the key thing is that Mr. Justice Henderson had to decide give answers to the agreed list of issues.
Exactly, yes.
And that's the key point.
That's the point. Now, if you were going to introduce an issue of discoverability, then what you would do is what we did in FII, which is not much later than this, which was include an issue specifically which says, what is the date of discoverability 2001, 2006, or some other date? And that's the issue which was determined by Mr. Justice Henderson and then went on appeal to the Supreme Court. So the point is, if there had been an issue here which said, what is the date of discoverability? Is it 2001, 2006, or some other date? Then that would have been decided by Mr. Justice Henderson. It would have been appealed, and that would probably have got to the Supreme Court before the FII case did. But it would have been the case that decided, that overruled DMG, almost certainly. But we didn't come along. The point is, you can't come along to a hearing to argue all the points of law and find there's a point of law that wasn't on the list, you weren't arguing, that has been said to be decided by the judge. That's not how GLOs work. Otherwise, there'd be no discipline. You'd be able to troll your way through the judgment and say, well, he's decided this point here, that must be binding on everybody. It's very important in GLOs that everyone knows what the issues are that have to be decided, particularly as people can have to appeal against them. Remember, I mean, my learned friend's argument is because the order in this case said the Prudential claims are in time, that would bind everybody in the GLO, and so because they could work out if they
well, there's not much point to making it a GLO issue if it only binds Prudential, and it wouldn't really be a common issue at all then.
Yes, but my point is it's not. If it was set down as a GLO issue and he decided it, I agree it would bind everyone, and that's why. And then it would be appealed almost certainly, as happened.
But wasn't this a GLO issue?
The date of discoverability was not a GLO issue.
No, but whether the claim was statute barred.
No, the issue was.
To what extent is the claim statute barred?
Yes, but that was regarded understood by everyone as an issue about relating back.
Well, so you say, but then I'm not quite sure. You seem to be jumping backwards and forwards with saying, oh, you have to look at the very precise wordings of the issue and what was decided, but then say, well, no, you can't look at the wording of the issue. You have to look at what was argued. So, which is? Well,
no, you have to understand what the issue is by what was argued and what was decided by the judge.
On the state of the law that everybody thought it was the claim statute barred?
It's just there was no contest about
to what extent,
because everybody thought they knew the answer to that, so exactly. They didn't argue about it.
Exactly. Just like everyone thought they knew the answer to whether Category A was...
Yes. Well, the only difference here is that was actually an issue and was actually put in the order. The answer was in the order, so there's no doubt about that. But in this case, there was no issue laid down as to when discoverability was. As I say, if it had been, one, it would have been argued, which it wasn't. Secondly, it would have been decided by the judge. It would have been embodied in the order as to what the date of discoverability is. And then it would have been appealed, as the FII case was.
Well, the argument is that he did decide that the date of discoverability can't be a date, outside whatever the 6-year period that he determined is.
The 6-year period before 2003?
Yes.
But that's not the date my learned friend's arguing for. He's arguing for two dates. One is 2003, is the date of discoverability, and the other one is 2006. So, I'm not sure where he gets any of these dates from. But your Lordship is right. The assumption underlay this would have been discoverability was, if anything, was not before 1998. Would have been the assumption that was underlying this on the basis of DMG.
I mean, the Court of Appeal is right that first question, to what extent is the claim statute barred by a 6-year limitation period, is a virtually meaningless question, isn't it?
No, it isn't, because...
I mean, so stated, of course,
Oh, yes,
subject
of
to a
course.
6-year limitation.
Yes,
I don't know to what extent is referring to, but
Yeah.
presumably some are and some aren't. But
Yes.
Any on
I mean,
it's claimed for.
yes, it's
I'm not-
very obscure.
I'm not defending the
No.
wording of this question, but what I'm saying is that it was not a question about discoverability, and it was never understood
Well,
to be a question.
isn't it asking, is the claim statute barred insofar as it relates to periods 6 years before the claim was brought?
Well, it's saying to what extent is the claim statute barred?
Yeah. Well, because some of the accounting periods stretched over quite a long time.
Well, the question is, assuming 320 is valid, then there would be a 6-year limitation period.
Yeah.
And the question is, this is asking, and I agree it's not brilliantly worded, is that 6-year period back from 2009, or is it back from 2003, essentially?
So your submission is that this was all about relation back.
Well,
anyway,
it is, and
the
yes,
effect of
exactly.
the amendment.
And that's supported by...
Is that supported by what Mr. Justice Henderson, how he approached it?
Exactly, yes. It's supported by the way he approached it. It's also supported by the way it's argued by both sides.
It's supported by his reasoning, yes.
Yeah.
But the
Everyone regarded it as a question about relating back.
1923 1A, the order, the order in relation to a GLO issue is said to be binding on the parties to all other claims. And the order in 11 on page 652 is that the claims in mistake are on time.
Mm.
So you're asking us to construe it in the light of the arguments advanced and say, well, it's not a general statement, it's confined to the issues that were argued before Mr. Justice Henderson.
Well, I think what I'm saying is, yes, that decided that the Prudential claims, which included claims more than 6 years, were in time. But if you're asking what is a GLO issue, there wasn't a GLO issue as to whether the Prudential claims were in time. That's not a GLO issue. And
But
we would say it's not possible to say, well, because they've decided these claims were in time, you can therefore reverse engineer and ask what the premises must have been on the basis of which that decision was made. And that all those premises will then be binding on all followers.
But the worry is that if the order had had an extra few words that said they're all in time because time started to run from this date or because of relation back or whatever, it's just a happenstance of the way that the order was drafted that it's not clear what reverse engineering there was, isn't that?
What you have to remember, my lady, is these orders are carefully agreed by the
Well,
parties.
they are, but
and we
by
would
the
not
time
agree. We would not have agreed an order which said, and Mr. Justice Henderson would have to have decided this, but we would not have agreed an order which said these are in time, decided the date of discoverability was X. Remember,
But if it had said they are in time because claims which are brought, any claims which are brought by this date are in time. That's what the other side need it to be.
Any claims brought by Prudential.
Well, why by Prudential? Any claims brought by anybody on the GLO register are in time.
But the problem with that is that people on the claimants in the register had claims at different times.
Yes.
So you can't say that, because they might have brought a claim in, say, 2008. So therefore, they wouldn't have been in time on the basis of the claim. Just because Prudential was in time wouldn't have meant they were in time. You couldn't have said that. The reason that we have the issue set down and there are test claimants with different dates is so that you can decide at what point they could have discovered their mistake. And it may affect, claimants who brought it in 2009 may be out of time, or 2007 may be out of time, 2005 may be out of time, depending exactly what the date is.
But did Mr. Justice Henderson decide that the claims did or didn't relate back, remind me, to the...
He decided they did relate back.
They did relate back. so that anyone who had brought their, just Prudential's claims related back, or anybody's claims?
Well, he was only dealing
with
Prudential's claims, because he was
so
dealing
the
with
PAC
the
and
facts
the
of those
PHL claims related back to the 2003 launch of proceedings in the corporation tax claims.
Yeah. That's what he decided. You can see that in his judgment that he decided.
Yes, we really need to look at what Mr. Justice Henderson said in the final section of his discussion of this. Really, paragraph 252 onwards, is it, I think?
Yeah.
Which is 2179 and following.
Yeah. And he deals with the second question, 257. Second question, assuming 320 to be invalid, is whether the ACT claims can be related back to the dates of the respective claim forms. The question is probably academic. It seems to me that the claimants would probably be able to rely on 32.1c. In case it matters, I'll briefly state my views on the question. And then he states his views that they did arise out of the same facts, etc., and therefore they could relate back. In paragraphs 258, 259. And then the final sentence is rather puzzling, because he then says it follows the ACT claims are deemed to have been commenced on the same date as the original claims.
Which paragraph are you in?
Sorry, the final sentence of paragraph 259 on page 259 on 2181. ACT claims are deemed to be commenced on the same date as the original claims, and leaving aside 32.1c, they are not time barred if 32 is invalid.
Right, so they dated back to 2003. But
Not sure that will make sense, to be honest.
I see.
I found that second half of that paragraph quite puzzling.
Yes. I think the truth is that nobody really thought this was a very important point, and it turned out to be completely academic. Because only a month or so later, the European Court decided that the 320 was invalid.
Well, at this stage, it was anticipated that it might well be invalid,
Yes.
because the Advocate General's opinion that it was already out.
Yes, and some of us had been to the court.
Yes, and
Really good idea of what was going to happen.
and the discussion that follows the start of 257 is on the assumption of the invalidity of section 320.
Yes.
But so if that's right, if they relate back to the start of the Prudential proceedings in 2003, if you've just got 6 years, then that goes back to 1997. But in Prudential, I think there were claims that went back further than 1997.
Yes, because they had more than 6 years, because they relied on 32.1c.
Right, so, but he decided that all their claims were.
Yes, I agree.
On what basis then?
On the base, I'm sure the basis of which he decided that was that DMG was the law and that they would be in time, therefore, under 32.1c. I don't think there can be any doubt about that. That was the underlying basis.
I know.
But the question I think you have to address is whether that
But I mean,
kind of
It can't be right, can it? If
deduction.
you leave section 32.1c out of account, and you look at proceedings issued in 2003 with a 6-year limitation period, that takes you back to 1997. It follows that any pre-1997 claims are statute barred, unless you rely on 32.1c.
yes.
So I'm not quite sure.
I did say the last sentence was puzzling.
You did.
Yes.
Indeed it is.
It means really,
Just
well, I don't know. Right, so you
I'm
do
not-
accept that his decision that they can pursue their claims earlier than 1997 must be on the basis that DMG is right.
Yes.
That that's the time that the limitation period did not start to run.
Yes. The question
Earlier time.
The question that you have to answer is whether that amounts to a decision on a GLO issue with 19.23.
You're saying it ought to have more precision than that so that people can understand what was decided, and you can't extract a GLO issue out of, so we're extrapolating the facts of this claim and then
Exactly.
trying to draw deductions from that.
Because you could do that, if you could do that, you could do that with any, not just this point, but any point that a judge has decided. You could say, well, he must have been assuming X, Y, and Z.
But I mean, you say all the parties agree the order, right? But by this stage, Prudential know they've won. They don't really care about what happens to the other follower claims. They know that whatever happens, they're going to get their money.
I don't think you can...
Not sure about that.
Well,
No, because
but for HMRC,
the lawyers are being paid by everyone.
The costs are being shared amongst the whole works.
Yeah, I don't think...
Yes,
you can,
so they couldn't take instructions purely from Prudential's own...
I wouldn't have thought so. I don't know anything about what goes on behind the curtain, but my guess would be that they must have a say in it. Because they're affected by the...
They were funding it, yes.
They're funding it, exactly. But this would be a wider point than this. It doesn't just... If you were to decide that's possible, then it would be something that could be done in any GLO, presumably. You could look for understated premises of decisions that have been made by the judge and say these are somehow binding. And the problem is that they can't be appealed. I mean, that's the fundamental problem with deciding this. If the judge had decided the date of discoverability is whatever date and had included that in his order as a declaration, then we could have appealed it, or the other side could have appealed it. Anyone could have appealed it.
So if you apply, just remind me please, if you apply DMG, what was the date of discoverability?
Well,
that's itself a difficult question.
Yes.
I mean, one view was it was the FII CJEU decision, is that right?
Yes.
Which was when?
2006.
But the alternative is it was Herxt, which was earlier in, I see. So if it was Herxt, then some claims issued in 2010 or 11 or 12, which might be bound by the GLO order, would be out of time. I see.
If they were on the register at the time.
If they were on the register at the time of the order, but had issued after, well, 2000 and whatever it is, 7, 8.
And the problem of principle of this is that in a case like that, these people couldn't possibly know. No. They would be obliged to appeal the order. They couldn't know what decision had been made in private, behind the scenes. This can't be a way of operating a GLO, in my submission. It just causes a recipe for absolute chaos. What should be done...
At the time of this decision of Mr. Justice Henderson, was this debate between the Herxt date and the FII CJEU date, was that a live issue at that stage?
Yes,
because understood.
Because as I said, in the FII case, and I think we can probably got the date somewhere, in the second FII round of litigation, Mr. Justice Henderson decided as one of the issues, it's the famous issue 28, which went to the Supreme Court. He decided that it was 2001.
And when did he decide that?
It was not long after this.
I see. So it was a live issue.
It was basically. If it wasn't 2014, it was. I think the hearing we decided was in May and June 2014, and the judgment was given.
It was a live issue.
Yeah. Yes, it was.
Yes, but in 257, in the Prudential High Court decision, he says that the claimants will probably be able to rely on 32(1)(c) on the ground that they could not have been aware of the invalidity of the ACT provisions before the CJEU FII decision in December.
But then he says something different in paragraph 255. He says, I don't understand the revenue to argue that PHL could have discovered its mistake before 14th July 1998. Which
is 6 years before they
issued the claim. Yes. Yeah. None of this is him deciding anything. He's just stating what he thinks to be the position.
that was the corporation tax claims, weren't
Yes, exactly. So,
and 257 is
for
the
some
ACT.
reason, there's a difference between them and the ACT claims. I'm not
Yes.
quite clear why there would be. And certainly in FII, the decision was in relation to all of the claims, both corporation tax and ACT. Can I just show you what happened in the Class 8 proceedings, which are also part of this GLO, because that's where this discoverability issue was fairly and squarely put before the court. Can I just take, it's page 686. I think. Well, this is this is an order made 27th November 2017 by the Chancellor, then Sir Geoffrey Voss. And if you look at Schedule 1, the issues, Class 8 issues, you'll see that Issue 4 is the question about constructive discovery. Can I just say something about the fact that it's Class 8? We would submit that has no significance in relation to what we're talking about today. The classes are put in for convenience to separate out the claimants who have different kinds of claims. But CPR 1923 applies to everyone who's on the register, whatever class they're in. That doesn't make any difference. These were claimants who had brought claims after March 2010, when there was an ouster introduced to prevent common law claims being brought in tax matters. But one of the issues in that was the date of constructive discovery. And the Chancellor decided, and this was before FII Supreme Court 2, so on the basis of DMG, he decided that the date was 12th December 2006. And that order...
So that was not Herxt, but FII CJEU 1?
Yes.
And what's the 13th of November 2000? What's the 13th of November 2012 date that he...
That was the second reference in FII. These were dates that were being put forward by the claimant.
I'm just wondering what their significance.
But it's this is exactly the same wording as in the FII GLO, I think, word for word. Same dates and the same wording. He decided that, and that is currently under appeal to the Court of Appeal. I'm afraid it's been stayed pending all these proceedings. So there still is an outstanding, that is still an issue. And we would submit that is the appropriate forum to decide that issue, the date of constructive discovery in this GLO. Is this issue which has been set down, been argued, been decided by the Chancellor and is now under appeal.
But that appeal has been stayed?
The appeal's been stayed.
Pending this hearing?
No, not this hearing.
Pending, no, I thought you said it was.
Other parts of this litigation.
Right, because everybody knows now that DMG is...
A bit of time in the Court of Appeal if we decided it here, wouldn't it?
Yes, I don't think there's any doubt that... yes, exactly.
So you're saying the Chancellor decided the Class 8 thing on the basis of DMG, but now we know DMG is overruled, so now it's when is the date of discovery is the issue.
And when we were asking for permission to appeal, I mean, I think it appears somewhere in the bundle, the reason we were asking for permission to appeal then was we were proposing to challenge DMG in the FII case. We hadn't done so yet. We were just, I think, about to. I certainly put it in permission application. So we wanted to appeal this to keep the position open, obviously, if it was reversed, as it was in the end.
I see.
Obviously, at that stage, nobody knew what was going to happen. It could have ended up not being changed, and then everything would have...
There's a few more years left yet in life in this.
We hope not.
Not yet see you to retirement.
I think of my children, possibly. Certainly. Mr. Bremner is coming up. Yeah. But that, we would submit that that's and that will certainly bind all those who are on the register at the time this is decided. And it does raise a problem that our understanding is that there are some people in the Class 8 who were actually on the register at the time of the order in 2014. And so they would be, in my other friend's case, they would be bound by that, as well as by this, I think. So this case creates a difficult position when you have situations where nobody knows that there has been an issue decided. Another difficulty with my learned friend's case is it's not very clear what he's actually saying was decided. He seemed to be saying at some point it was either 2006 or 2003. Well, that is a hopeless situation if nobody knows, nobody can tell what actually has been decided on my learned friend's case. Very case, he says that these are two possible dates, depending on how you construe everything that's happened. And that just can't possibly be right. Possibly be a way a GLO would operate, that until the Supreme Court has sort of gone through the runes and look at all the past, what has happened and what points have been argued and what's been assumed, that nobody knows what the date is that's been decided in 2014. As my learned friend said, this was decided in 2014. But he still can't tell you what the date was that was actually
Well, he has
decided.
two alternative dates.
Oh yes, but that, in my submission, that's hopeless to have a two.
Well, you say it's hopeless, but sometimes you have, when you have to construe something, sometimes there are alternative meanings of it,
Well, you shouldn't,
and you argue about
I think my submission is you shouldn't have to construe anything.
Well, you shouldn't, but that's the orders, that's always, you can say, if they're more clearly drafted or people had anticipated things which they didn't, then the problem wouldn't have arisen.
But if there had been a GLO issue specifically set down on this point, it would have been decided clearly. You would have known what the date was.
But as I
you wouldn't have
understand
had to interpret anything in my submission.
the two alternative dates are not actually two alternatives for when the limitation period actually started to run. The second alternative date is, well, it can't have been before that because all the claims going back to then have been allowed. So it
That would
must
be
have been
1998, not 2003. Yes. But my learned friend's putting forward 2003. Difficult to see how that can be the date when the limitation period started.
But I thought his alternative was a 1997 date.
If it's 1998, then that's... But there's a big difference between 2006 and 1998.
But the 1998 date is not actually a date. It's only 6 years. It's not a date on which something happened. It's a date which is 6 years before
exactly, but
the 2004
in order to
proceedings.
If you have a claim that's been brought more than 6 years after that date, you will have to then litigate to decide whether, because all that's been decided is it's not before that date.
Yeah.
So it won't help you. So essentially, that is the cut-off date on that. Anything before that date, anything 6 years goes before that date would be covered by that formulation, I agree. Anything after that would not be covered by it and would be at large still. But there's a big difference between that and a 2006 date, which is 8 years later. These are two very different days. But I just go back to my point. If someone has got to do all the work that my learned friend has done to work out what the date is and still can't decide, how on earth are they supposed to operate a system where you have to appeal the decision? And more fundamentally, how could they appeal this order? Because this is an order that Prudential's claims are in time. So someone else appeal, how could they appeal that? Impossible, in my submission. Nobody could appeal that order, apart from the revenue, obviously. But no, Prudential could appeal it because it won.
Well, why would they want to?
No, exactly.
They wouldn't.
But nobody, my point is...
Nor would anybody else.
Well, they might, because they might want to say that if it was the case that the result of this was inferentially the date was 1998, let's say, someone else might want to say, no, actually, it should be 2005.
Well, I think on any view, all that it could have decided was that a claim, because of the decision that they were Prudential claims were brought in time, then a claim would be in time if it was brought by a particular date.
Yeah.
You couldn't be prejudiced by that decision.
Yeah. Yes.
If you're a claimant.
Yeah.
It might not do all you need it to do.
As long as it wasn't a specific date, it was not before date. But then the other thing is, would the revenue be able to appeal it, and on what grounds? I mean, they could appeal. They could appeal that Prudential's claims were not in time. But if they accept they are in time, but other people's aren't, how would they be able to appeal it? I wonder. That's the difficulty with this. I mean, this looks like, on the face of it, an order about Prudential, my submission, and it's bringing to an end Prudential's claims, or determining them. But it doesn't.
Well, presumably you wouldn't want to, if you're going to concede that Prudential's claims are brought in time, you're also, I would have thought, accepting that anybody else's claims were brought.
No, my lord, because
later.
one of my
earlier were brought in time.
One of my learned friends' alternatives is that the date of the constructive discovery is 2006. That doesn't just affect Prudential; that would affect almost everyone in the GLO. What he says is you can deduce from this order that the date of constructive discovery is 2006. Now, if that's right, then the revenue would want to certainly appeal that. Would have wanted to appeal it at the time, but how on earth could they, one, have known that they should appeal it, and two, well, they did try to appeal it when they were refused on the grounds that, as far as Prudential was concerned, it was common ground that they were in time, which is absolutely true. But that's the problem with saying that as a result of this order, the date is 2006.
No, but I mean, if you look at paragraph 257, 32(1)(c, and the date of December 2006 is cited in support of the proposition that the question he was answering was probably academic. But he then answers the question.
Yes, it's a question anyway.
Yeah.
Yes, but I'm looking.
There isn't a ruling that it's 2006.
There isn't a ruling. There isn't a ruling in my submission. There isn't a ruling that it's not before 1998 either. And what you have to look at, and this goes back to the point about the judgment or order, what you have to look at is the order, which I think is why my learned friend has...
Just one. If the date was 2006, why did it matter whether the claims could relate back or not?
Well, if it was 2006, it wouldn't matter, and that's why he says it's probably academic. But I'll answer the question.
It only matters if Section 320 was valid, and therefore 32(1)(c) didn't apply.
Yeah.
Well,
That's where I think the judge got it the wrong way around. I think he thought it was invalid, but actually,
Yes, he should have said
I think the judge
valid.
may have got that the wrong way around in his judgment.
Yeah, this is 257. He should have said, second question, assuming 320 was valid.
Valid, exactly, yes, I think so.
I see.
I can see that, yes.
But to be perfectly honest, I don't think anyone, until these proceedings started in whenever it was, 2022, I don't think anyone ever looked at this part of the judgment. And it was completely academic and irrelevant.
I think we see that from paragraph 252. Neither question was argued in detail or at any length.
Yes.
From which I infer that the answers are not perceived on either side as having much practical significance.
Yes. Well, they are now, it seems. Yeah.
Yes.
I think there's only one further point I would like to just make on this, which is in their case, in the amendments they made to their case, right at the end of the appellant's case, in paragraph 140, capital H, which is on page 6970 of the key documents bundle, they make the point, we had said this was going to cause an inconsistency because when the followers' claims have to be determined, there are two questions. One is when did they actually discover their mistake? And the second is when ought they to have discovered their mistake, which is the discoverability question. And of course, both of these are affected by FII Supreme Court 2, because the question of what is a discovery affects the question of when you actually discovered something as well as when you could have discovered it. And we were saying, we said, well, that you'd have to determine the factual question about actual discovery on the basis of Supreme Court 2, the law as it stands. And it'd be very odd if you were determining constructive discovery or discoverability on the basis of the old law, DMG. It seems that their answer to that is both have to be decided on the basis of DMG. So if you have a follower, the question is, did they actually discover their mistake more than 6 years before they brought their claims, say in 2008 or something? That question has to be decided on the basis of DMG. And the answer to that is it's impossible under DMG to discover your mistake before the court has told you. That's the point about DMG. It says you don't know the truth until you've actually got to the final. So nobody could have discovered, in inverted commas, their mistake under DMG until 2006, even if they actually had discovered it and actually had brought a claim before then, which is that paradox. That's a paradox.
That is the DMG paradox.
That's a paradox, yes.
People were litigating for several years before they knew.
Yes.
Well, they could
discovered they'd a claim.
Exactly.
Yes.
So anyway, the point is being made. I think their answer to that is no. You'd have to determine both of these questions on the basis of the law as stated in DMG. And the question we would ask to that is why on earth could that be the case? Because nobody, well, it's not a GLO issue, a common issue as to when someone actually discovers their mistake. That's a question of fact, which is different for potentially for each claimant.
You'll have to bring things to a close.
I have finished.
Thank you very much, Mr. York. Mr. Bremner.
Obliged. My Lord, 5 points in reply. 3 on ordering otherwise and 2 on limitation. First point, my learned friend accepted at about 20 to 1 that, as he put it, it's not in every case where the law changes that you get an otherwise order. Problem with the Court of Appeal's analysis in this case, and the problem with learned friend's attempts to support that analysis, is that there is no principled reason for permitting an otherwise order in response to some changes in law, but not in others. What this shows, in my submission, is that the change in law situation of the kind we're dealing with here is simply not apt for an otherwise order. Here we have the same defendant, and that very defendant had conceded the argument. The defendant now wants to introduce points of law that it had expressly conceded in the test case. Those points were always available for the revenue to take they chose not to take them before Mr. Justice Henderson. And in those circumstances, there is no injustice. That must be the relevant question if we get that far. No injustice in the revenue being tied in to the ruling in the test case. That's the first point, the lack of principle in the Court of Appeal's ruling and in the revenue's defence of this appeal. The second point, and this ties into the point I've just made, it relates to the House of Lords decision in Arnold and National Westminster Bank, which has been mentioned a couple of times, both by me in opening and by my learned friend. I don't think we've actually opened it, and it may be that at 3:10 it's not a sensible thing to start to do that. We've trailed it a little bit in the written cases. What I would say is that it is very important, if one is looking at Arnold, to appreciate that there were particular factors in that case which grounded the conclusion that the case was the exception. And those factors go well beyond the simple fact that the law changed. There were 2 points in particular. The first was that there was no right of appeal against Mr. Justice Walton's judgment because he'd refused, and in parentheses one can see in the House of Lords speeches fairly clearly it was viewed to be wrong, that refusal.
Well, it's a pretty extraordinary thing that a judge gets to decide whether there can be an appeal against their decision.
Indeed.
Which is an anomaly of
and to refuse to grant a certificate of public importance where it had then, the very same issue had then cropped up in other cases and opposite conclusions had been reached was highly unusual. And that is a point that's emphasised. You'll see it in the bundle, Electronic 1464 letter D. I mean, I'm very happy to turn this up if you'd find it of assistance, but I suspect it's enough for me simply to make these points.
What was the reference again, please?
It's 1464 in the bundle.
64, that's fine, I just want to...
At the letter D.
Letter D, thank you.
And the second point, which is also in 1464, this time at the letter F, was that absent agreement, there needed to be arbitration at each successive rent review date. And that was what led Lord Keith to observe that the public interest in seeing an end to litigation is of little weight in circumstances under which, failing agreement, there must in any event be arbitration at each successive rent review date. So this is a pretty extreme case, as indeed one will be able to see if looking onto the letter G at 1464, because the conclusion is that abuse of process would be favoured rather than prevented in the circumstances of Arnold by refusing permission to reopen the disputed issue on the basis of issue estoppel. So Arnold is not authority from some wider principle that change in the law of itself justifies the undoing of the estoppel. It's not a case that when there is a change in the law that will justify allowing the question to be reopened. Has to be unjust for the party to be tied in. And there is a striking contrast between Arnold and this case, where the revenue did not take the point that they now wish to take, either of them, in front of Mr. Justice Henderson. And that is so notwithstanding that they could have taken the set-off point, or indeed the limitation point at any stage. They tried to introduce limitation point, but it was their own failure to argue it in front of Mr. Justice Henderson that led the Court of Appeal to refuse permission, paragraph 158 of the Court of Appeal's judgment. Nothing like the situation in Arnold and NatWest, where the litigant throughout has tried to say, here's my construction of the rent review clause, you've got it all wrong, and because really of error on the part of the court, they were prevented from running that argument at higher level. So the reason why the revenue has refused permission to appeal in Prudential Court of Appeal, it's not any sort of procedural irregularity or unfairness. It's just because they've conceded the point of below. What's happening on my learned friend's approach is it said, well, somehow this case is exceptional. We would have had to have been very prescient to have taken the Sempre point or to have mounted an argument that DMG was wrong. But in my submission, it's well recognised law can change. It was perfectly open to the revenue in Prudential. Just as much as ultimately in FII, it said to this court, we would like you to overturn DMG. Exactly the same argument could have been run in Prudential. And the argument that Sempre is wrong, that could equally have been run in Prudential. And it shouldn't be a matter of looking back to academic commentaries to say, well, was there criticism of the judgment? Was there some groundswell of opinion that might suggest that the case should be looked at again? Well, I dare say that one could identify quite a lot of academic commentary on, for example, DMG. I can certainly recall the late Professor Burke's writing an article where he was highly critical of that very decision. I dare say there are articles about Sempra as well. What sort of test is this that my friend is asking this court to bless? It cannot.
Would it have made a difference if they had argued it had been decided against them and they were refused permission to appeal?
Well, potentially, that's not the world we're living in.
Yeah, I just ask you whether it would, in your submission, make a difference. Would that be a significant change?
That might be a change that one might have to weigh in the balance if we get to the stage.
What do you think?
Well, I'm accepting that it might be. So they're the first 2 points. The third point and final point on ordering otherwise. My friend said, this was at about 2:10, that there was something very odd, he said, about a claimant saying the law is X when you know it to be Y. The court will recall that was under reference to paragraph 77 in the Court of Appeal's judgment, the observation that the GREA claim remained to be tried. Really, that just restates the point that the law has changed and there hasn't yet been a final determination of the particular claim under consideration. I simply go back to my point that when we talk about the correct law, in the context of this regime, it is the law as set out in the test case. And there's nothing odd about this. The court will see, if it wants to see an example, this is in the issue estoppel context, so this is actually even removed from what we're talking about. But Lord Neuberger in the Virgin Atlantic case, he gives an example. It's paragraphs 46 and 47 of his judgment, electronic 2405. And he's simply making the obvious point that judgment in other litigation doesn't affect the rights of parties to each set of proceedings inter se, is how he puts it. 2405. So Virgin Atlantic is complicated because of the points about patent law and the retrospective effect of a finding of invalidity. But Lord Neuberger is dealing with a much simpler case. A is lost against B on an issue in one case, and it's irrelevant to A's legal obligations and rights as against B if C subsequently defeats B on the very same issue, although, as he notes, it may help A to obtain permission to appeal out of time, and gives Arnold as an example of that, where indeed that possibility is canvassed. And he gives the example of re-wearing in 47. It's a rather old tax case from the 1940s about annuities under a will. And it so happened there was a decision of the Court of Appeal in relation to one litigant, decided one way. Another party was not party to that decision, to that decision, and there was a later decision that was more favourable. And Lord Neuberger simply observes that the two decisions are applied. And in the final sentence, the judge in that case had acknowledged the result may appear to be anomalous. In reality, it was a clear and principled application of the fundamental rule. That's in the context of estoppel. That's before we even get into the considerations relating to GLOs that I'm relying upon. So I say there's nothing unjust about the revenue being bound by the result in the test case. On limitations, so this is my point 4. My friend sought to present the issue in Prudential on limitation as really being about relating back. That doesn't work. Paragraph 107 of Prudential, which is page 2130, tells us that the claims go back to 1990. You can also see it as it happens in 113, where Mr. McCulloch's evidence is set out.
I'm so sorry.
It's 107.
107.
This is page. Sorry,
It should be 2130.
It is, yes.
2130.
That's actually drawn from some evidence from Mr. McCulloch, which is set out in 113 on 2131, and within paragraph 103, it's when paragraph 41 is quoted, it's the same point, and as it happens, the point is reiterated in paragraph 249, page 2178. Prudential needed 321C in order for any claim for a payment of tax made more than 6 years prior to the date of issue to succeed. That's irrespective of relating back. Whether or not they got home on relating back, they needed 321C. My own friend was disposed to accept at around 2:25 that what he called the sub silencio assumption was that DMG was the law and Prudential was in time if Section 320 was invalid. I say absolutely right. That's the assumption the Revenue explained to the Court of Appeal in its skeleton argument, which I showed this court in opening. He tried to say that that concession only applied to Prudential. That doesn't help him. This is a concession in the test case. There plainly is a GLO issue. The GLO issue is to what extent are the claims statute barred by a 6-year limitation period. That's issue 7.1 on page 659. My own friend sought to say, well, this is all very confused. It's all going to be very difficult. How do people with later claims know if they need to challenge a ruling? My Lady Rose, I'd respectfully suggest gave the correct answer to that rhetorical question that my own friend asked, which is that the dates in question, they are not before dates, if I can put it like that. So the dates I'm relying upon are dates, if you bring your claim on or before that date, you're in time. It doesn't follow that if you're later, you're out of time. So my own friend's submission rests on a misunderstanding of what the nature of the issue actually is. There isn't a ruling that later claims are necessarily out of time. That actually is why the Class 8 proceedings were necessary, because they are later claims that need a later date. That's why there is a different issue identified for those Class 8 claims. My own friend also suggested, this was about 2:50, that by the time of the Prudential order, I think he said...
So you say that the not before date is binding on everybody who's brought their claim by that date?
Yes, and who's on the register
and who's
at the time of the Prudential order. Absolutely right. I'm just going to
do not depend on what years their claims relate to.
I'm not sure I quite follow the question, my Lord. I'm sorry.
Are you saying that the decision, you can just say that everybody who brought a claim after by a certain date is in time, regardless of what years they were claiming for?
Yes, because the basis of this is that the mistake was not discovered and could not, with reasonable diligence, be discovered before that date. So anything within 6 years of that would be in time. Yes. And I don't shrink from that. On the law as set out in DMG, nothing is discoverable until the proposition of law was there to be discovered. That's what DMG decided. So there's no difficulty with any of that. And we're looking in this GLO at essentially two specific tax provisions.
I'm just working out what you need to know in order to interpret the order.
Yes, not very much is the answer in my respectful submission. One point of detail, my own friend suggested at about 2:50 that by the time of the Prudential order, the 8th of March 2001 date was something that was in issue. I don't think that's right, although I don't think we've got the material in the bundle to go and check it. My recollection is that 8th of March 2001 was added to the list of issues in FII for trial. That trial took place in May-June 2014. This is discussed by this court in FII Supreme Court 3, paragraph 49, which is in the bundle at 1751. I was able to check, although again this is not in the bundle, the Revenue's defence in FII, which was filed I think in February 2014, simply admitted that BAT's claims were in time. But so far as I can tell, there's no sign that the 8th of March 01 date was in play by 28 January 14, which is the date of Mr. Justice Henderson's order. On the dates themselves, there was some discussion of 1998, 1997. 1998 features in Mr. Justice Henderson's judgment at paragraph 255. That is the date 6 years before PHL brought its claim. That's why it's being mentioned. I'm simply making the obvious point of if that's the date, that's good enough for AXA UK, because it brought its claim on the 8th of April 2003. As it happens, one could also make a different point. PAC's claim was held to be in time. That was also brought on the 8th of April 2003. That would support, as it happens, a slightly earlier date.
But does if it's 6 years before PHL's claim, but does that mean that losses before 1998 are not recoverable?
No, it's the discoverability.
That's exactly right.
Oh, I see.
6
It's the
years
discoverability.
And there's no limit as
How far back you can go.
how far back you can go
Yes.
if you didn't know
Sorry.
you had the claim.
Yeah.
My Lord Hodge is right, yes. Once you are within 6 years of the date of discovery, you can go back without limit in time,
Yes.
which, of course, is the problem that this court was concerned to address in FIISC 2. So there's no difficulty on the dates. There was a suggestion late in Milano Friends submissions that Mr. Justice Henderson in paragraph 257 that he'd got the matter the wrong way round, because he should have been approaching this on the basis that section 320 was valid, not that it was invalid. That suggestion is wrong for two reasons in particular. If section 320 is valid, section 32(1)(c) is turned off. And it would make no sense at all even to be talking about being able to rely on 32(1)(c), as Mr. Justice Henderson does in paragraph 257. There is also a slightly more involved point, which is that if one looks at section 320, one of its...
But isn't 320 annulled section 32(1)(c) after a certain date, claims after a certain date, isn't it?
Yes, that's right. But
can you remind me the date?
So it was enacted on the 24th of June 2004. That's recorded in paragraph 250. And I think it was backdated to September 2000.
8th September 2003.
When it was announced.
2179.
I'm very grateful. Your Lordship is quite right. Claims actions brought on or after 8th of September 2003. And that is explained by Mr. Justice Henderson as to the scope of 320, because he deals with that in particular in 254, because he sets out which claims are affected on the footing that the that the section is valid. And there are claims after that date in 2003. So for those, if 320 is valid, 32(1)(c) is turned off. There may be something to say about relating back, but there's a slightly more technical and convoluted point, which is that the other thing that 320 was also trying to do was turn off relating back. And you can see that in subsection 2, which is 2179. And in subsection 6, this, of course, was drafted before this court decided FIISC 1, but on its face, 320 applies to any action or claim for relief from the consequences of a mistake, essentially however expressed. So at the very least, it's trying also to stop relating back for the Woolwich claims. It's certainly doing so for the mistake claims. So as I say, one cannot, it's wrong to say that 257 has got the matter backwards. It only makes sense on the footing that 320 is invalid.
Well, did the CJEU find that 320 was invalid both in relation to A and B?
I'm sorry, I'm not sure I could follow both in relation to A and B.
Well, to A and both, it was both invalid by disapplying the Limitation Act and also disapplying relating back under the rule.
I think, my lady, it must have done because the vice of the absence of transitional provisions is the same. But as I'm not sure that was canvassed directly in ECJ.
So if 321, if section 320 was valid, then relating back was also academic because you couldn't extend back your claim by relating the added claim to the original.
Well, it depends because the judge sets out in 254 what his view of the position is if the section is valid. He deals in terms in 254 with the position on that assumption, that is, if the section is valid. That's what's being dealt with in 254. And there's then a sharp distinction because 255 and following is if, however, the section is invalid. Now, my own friends sought to turn that distinction upside down and say that Mr. Justice Henderson got it backwards. And my submission is that, one, is a very surprising conclusion, and two, it's not actually right when you look at what he's dealing with. And I hope I've explained why. Fifth point was just to deal with a couple of the points that arise out of the Revenue's Respondents' notice, and which my own friend also touched on orally. Sub-point 1, there was a suggestion that the date in Prudential of 8th of March 2001 did not matter. That isn't right. What the Revenue would have needed to have done was proceeded in two stages. They'd have needed to say the date can't be later than 8th March 01, point 1. Point 2, you can't relate back. And had they been able to make those 2 points good, if you look at when the claims were brought, then they'd have been able to say that the amendments 2008 and onwards, so F, G, H and I, were out of time. That's why my own friend was trying to introduce this point in the Court of Appeal. But the reason none of it mattered was because he'd conceded the point that 32(1)(c applied. That second aspect of the Revenue's Respondents' notice was on Class 8, where it was suggested that Class 8 has somehow superseded Prudential. That's wrong. We explained that in our written case. It's 140 capital B to G. Class 8 is a test case only for the claims in Class 8 of the GLO, and neither AXA, IUK, nor GREA are in Class 8. That is paragraph 1 of the Chancellor's order of 27 November 2017, which is on pages 685 and 686 of the bundle. It says that in terms. So the Class 8 test claims are test cases only for claims in Class 8, and these claims are not such claims. The reason for that is that the Class 8 claims were claims issued much later, and so the Prudential ruling didn't necessarily determine them. And then the final point is the point Leonard Friend raised at 3:05, saying that, well, there's inconsistency because actual discovery would be different. No, it's not, and I rest on the explanation we give in paragraph 140H in our case. In Prudential, necessarily, both actual discovery and constructive discovery were determined, and it would be wholly inconsistent for the Revenue to reopen actual discovery given the ruling in Prudential. My Lord, unless I can assist further, those are my submissions in reply.
Thank you, Mr. Brennan. Well, the court is very grateful to counsel for skillfully taking us through this labyrinth of litigation. And it won't surprise you that the court will take time to consider what is the right answer. The court will now adjourn. Thank you.